As it is 5:31 on Thursday, July 11th, I will now call the meeting of the Deschutes County Planning Commission to order. Our first item of business is to approve the minutes of June 13th and June 27th. Do I have any? I'm not sure everyone was present June 13th. Those that were present, do I have any objections to approval? All in favor, raise your hand. All right, my hand is raised. We have 6 approvals, and as I was the June 27 meeting, I will approve those minutes myself. And do we have anyone either present publicly or online that would like to make a comment that does not apply to items on the agenda for tonight? As I'm not getting feedback, I will state we do not have any public comment, and we will go on to our first action item, which is public hearing mini storage in the MUA 10 zone.
Right. Good evening, commissioners. For the record, Nicole Mardell, Senior Planner, Deschutes County Community Development. I'm just waiting for my PowerPoint to get pulled up here, and we'll run through our opening statement for the hearing. Okay. So this is the time and place set for hearing on file number 247-23-0000732-TA concerning legislative text amendments to allow mini storage in certain areas of the multiple use agricultural zone. Staff will outline the hearing procedures that will be followed. The Planning Commission will hear oral testimony, receive written testimony, and consider the testimony submitted at this hearing. The hearing is also being recorded. The Commission may make a decision on this matter today, continue the hearing to a date certain, or leave the written record open for a specified period of time. The hearing will be conducted in the following order. Staff will give a brief report on this issue. The applicant, Schwabe, Williamson, and Wyatt, will present their testimony and evidence, aiming for a 30-minute time limit, although that's at the discretion of the chair, and will then take testimony from agencies if present, with a 10-minute limit per agency. Next, we'll take testimony from interested persons with a 3-minute time limit for each individual. Following testimony, the commission can then ask questions of the applicant or staff as well. This is a hybrid public hearing with options for both in-person and remote participation. For our in-person participants, if you wish to testify, please fill out a blue sign-up sheet and submit that to staff after your name is called. And in this case, because our chair is remote, if the chair is amenable, we were thinking the vice chair could call those individuals up. Once your name is called, please come up to one of the tables at the front of the room before beginning your testimony. Before starting your testimony, please provide your first and last name as well as your mailing address. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Chair Williams asks if anyone would like to testify, you need to use the raise hand feature to notify the commission. To do this, you need to press the raise hand button on your computer or smart device, or if you called in, you'll dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me after you speak. If you're participating remotely, you can submit your written testimony via email to my address here, nicole.mardell@deschutes.org. The chair and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Questions to and from the chair may be entertained at any time at the chair's discretion. Cross-examination of people testifying will not be allowed. However, if any person wishes to ask a question of another individual during that person's testimony, please direct your question to the chair after being recognized. The chair is free to decide whether or not to ask such questions of the person testifying. Prior to commencement of the hearing, any party may challenge the qualifications of any commissioner for conflicts of interest. This challenge must be documented with specific reasons supported by facts. Should any commissioner be challenged, the member may disqualify himself or herself withdraw from the hearing, or make a statement on the record of their capacity to hear and decide this issue. At this time, do any members of the commission need to set forth any information that may be perceived as a conflict of interest?
I will speak. I work with Ken Katzeroff on a current land use application, the applicant's attorney. I still feel comfortable to participate in the public hearing and upcoming deliberation. Just wanted to disclose that.
With that, does any party wish to challenge any commissioner based on conflicts of interest? And as hearing no challenges are presented, the hearing is now open, so I'll proceed with my brief staff report. So as I mentioned, this will be very brief, since you've already had a work session on this topic and the applicant will also be providing quite a bit of detail. But just some housekeeping, the project website is shown here, deschutes.org/highway 97 storage. That contains all public comments, all applicant submittals. So the Planning Commission is responsible for viewing that. I did want to note, we got a few new items from the applicant. We received, following the work session, a written response to some of the questions that were asked. And we also today received a copy of a transportation analysis that was following up on a request from ODOT. So those materials are in the record as well. We'll go back to the PowerPoint. Thank you. So the proposal this evening is to amend our multiple use agricultural code section related to allow conditional uses rather. So the applicant Schwabe is seeking to allow mini storage as a conditional use in areas that are within 2,500 feet of an urban growth boundary, adjacent to Highway 97, and at least 10 acres in size and no greater than 30 acres. Wanted to note, of course, that this is separate from the Highway 20 proposal that you had a hearing on in June. In reviewing the proposal, the proposed criteria with our GIS kind of database, we found that about 50 properties would be eligible for mini storage as part of the criteria presented in the proposal. About 13 of them were located in the Redmond Urban Reserve area, shown here in yellow. So wanted to note, as I discussed during the work session, this comes with some extra process as these lands are intended to be preserved for future urbanization. So typically they're meant to be holding lands. We did bring this to the consultant's attention, and they noted that they'll plan to provide an extra criteria to exclude these properties. So there would be less properties included in that eligibility. Wanted to note with a disclaimer that there could be additional properties that would be eligible if an urban growth boundary expands or if multiple parcels were reconfigured or used together to meet that minimum parcel size. As the Planning Commission knows from the work session, this is a use that's allowed in a variety of other zones in Deschutes County. Primarily, it's allowed as a conditional use, and it's primarily allowed in our unincorporated communities. It's also allowed in the rural commercial zone and rural industrial zone. Although I wanted to note that in each of these zones, there are quite a few additional criteria that come into play to reduce, visual or, traffic related concerns from these operations and adjacent properties. So it's pretty common in our other zones to see things like square footage maximums or screening requirements or traffic ingress egress requirements. There's also specific conditional use criteria as well in our code for those facilities that apply no matter what zone it's in. At the work session, there was a question from the Planning Commission on the number of facilities that are currently existing in Deschutes County. So wanted to note that we have 8 facilities from our research. 5 of those were approved prior to our modern code. So prior to that kind of unincorporated communities code work that was done to ensure that uses were rural in nature. So they were approved primarily in the 1980s and 90s. There were a few others outside of this that were approved that are now within city limits. So for instance, Deschutes County previously approved some mini storage facilities in La Pine, but since La Pine is incorporated, so it's under the zoning and they manage it. There's only one caretaker residence from what we could see. As part of these mini storage facilities, that's a part of a development in the Sun River Business Park. So it doesn't look like it's very common for folks to propose that caretaker facility, even though it's allowed as part of the conditional use criteria for mini storage. The zoning of the properties in which there's approved and operational mini storage, we have 3 in the Rural Service Center. This is no longer allowed in the zone, so that's primarily the facilities that were approved prior to that code work in the late 1990s, early 2000s. And we also have 1 in the Sun River Business Park, as I mentioned, 1 in the Tumalo Industrial Zone, 1 in the Terrebonne Commercial Zone, and 2 in the Rural Industrial Zone. In the record so far, we've received 2 agency comments, 1 from City of Redmond expressing some of the concern regarding those Redmond Urban Reserve Area properties. Although with the addition of a new criteria, they noted they'd be satisfied with the proposal. We also received a comment from ODOT, Oregon Department of Transportation, requesting transportation planning rule findings, and the applicant has provided some of those materials into the record. We did receive late this afternoon a submittal from Central Oregon Land Watch. Their staff attorney had an accident today, mountain biking accident, so he was planning to attend in person, but instead sent over his written materials. So you'll find that in the record as well. Generally, the letter expressed opposition to the proposal, and I believe there were 7 or 8 issues raised in that comment letter that you can go through in detail. But to summarize, primarily related to that goal 14, urban uses on rural lands topic that we have mentioned previously, some concern about the goal 5 EC analysis provided by the applicant, and just some concerns about compatibility with other multiple use agricultural zoned properties. With that, wanted to note next steps. The Planning Commission, as I noted, has several options to move forward this evening. You choose to continue the hearing to a date and time certain, close the hearing and leave the written record open for a date and time certain, close the hearing and set a date for deliberations, or close the hearing and commence deliberations today. So with that, we'll turn it over to the applicant for their presentation, unless planning commissioners have any questions for staff. Great. All right, we'll turn it over to the applicant then.
Would you mind putting back on the view of the room? Thank you very much. Good evening, commissioners. My name is Ken Katzroff. I'm an attorney at Schwabe Williamson and Wyatt, and I'm also here on behalf of Kramer Farms and Lafke Properties LLC. I will keep my presentation very short. I don't think I'm going to hit that half an hour, or at least that was my plan. I also wanted to apologize for not being there in person. I did come down for the previously scheduled hearing, which was then moved to this date, and was not able to make it down to Bend. I typically travel around for hearings, but not this time. So I apologize for that. But I had intended to be there in person. If there's any questions at any time, please feel free to interrupt me. But I'm going to try to run through this as quickly as I can. As staff noted, this commission has already looked at I'm going to call it a substantially similar application, although it's different in kind of the geographical area. And so I think, are familiar with some of the issues here. I also wanted to note, as Nicole said, we provided a traffic analysis today, which seems to have satisfied ODOT's concern at this point, which was to, per their email, at least as of right now in the record, just putting potential applicants in the future on notice that additional permitting through ODOT may be required for access requirements onto the highway. That's a pretty typical process. There's a lot of areas of land use where a county, for example, will approve a quasi-judicial application, and it still requires additional permitting from other agencies, be it Department of State Lands for a wetland issue or ODOT for an access issue. So we're comfortable with that. I just wanted to say that we've, I think, addressed ODOT's concerns at this point in time, although if the record is left open, I guess they'll let us know. I wanted to point out, I've also been tracking, for the most part, I'm going to call it the companion text amendment. And there were some questions about demand and need. And I would say that respectfully, there's no need criteria either in the county's code or in state law. And this comes up quite frequently, again, in quasi-judicial matters where somebody says, well, you should have to show a need for I'll use a gas station as an example. You should have to show a need for that. Well, that's not a criteria under the code or state law. And so any sort of determination that, let's say, denies a proposal because you can't show need or market demand per se, would run afoul of how the county needs to actually adopt a decision, which is based upon the criteria and the applicable criteria itself. I'd also say from a practical standpoint, clearly somebody's paying for this application as well as my time. And if the applicant didn't believe or the other folks didn't believe that there was a market or a demand for it, they wouldn't be making this request before the county. So I just want to put that out there. I thought it was interesting. I hadn't heard from staff before that there were other facilities that were previously in the county and have now been brought in to urban growth boundaries, and Lapine in particular, I think, was mentioned. And I think that's interesting to know because it shows it's not inconsistent actually and does not prevent expansion of UGBs. Nevertheless, we have already suggested an additional criteria that says that essentially this use, mini storage, RV, boat, et cetera, storage, will not be permitted in lands that are designated for urban reserve areas. And the point of that was to address the city of Redmond's concerns, as well as that second point that Nicole said, that if in fact urban growth boundaries do push out, there could be additional properties that would be eligible based upon the distance criteria that we've so far crafted. My point is if you're doing an urban growth boundary expansion, there are oftentimes, although not always, also a companion urban reserve area that is adopted. And so that would, if the city or the county, when it changes the urban growth boundary, which is required by the county as well, if they're going to look at doing that, they could simply also adopt an urban reserve area, if that makes sense. And that would preclude additional development of these facilities and properties that are deemed to be maybe not appropriate. One of the things that I wanted to talk about briefly was that our criteria says that a particular property needs to be 10 acres, but no greater than 30. That is not saying that facilities are going to be 10 acres or 30 acres in size. What that's saying is that the property or the conglomeration of multiple lots has to be that big. And we picked that number, I would say not really out of a hat, but because there are additional competing interests related to compatibility, suitability, et cetera, when we're looking at these areas. So under the LM zone, for example, you have to have certain distances, you have to have certain screening, et cetera. Same with the conditional use criteria, both the general criteria and the specific to mini storage, and then again to site plan. And so what we have to do when any applicant would come in for a potential proposal on this, on a quasi-judicial matter, is address all of those. And the thought process was that a property should be large enough that it can pretty much be well screened and have very little or low impact on adjacent properties. But that's a determination that's going to have to be made on an application by application basis, as you would on any quasi-judicial matter. Not something that the Planning Commission typically deals with, but it's something that is built into this proposal. We're not asking for an approval of any particular facility. We're only asking that a particular property owner have the opportunity to even seek this use and then go through a new and substantial public process that would vet all of those issues, including access, including screening, including Goal 5 protected view sheds, those sorts of things. So that's the purpose of that. I didn't know that Roy had an accident. That's a bummer. I hope he's okay, sincerely. But I did already put together some responses to his letter. And so typically we would do that in rebuttal, but given that he's not there, and I can't see the room, Nicole, are there other people in the public that are planning to testify, or should I go through what I would typically have done as rebuttal now?
We have
Or the chair,
two
sorry.
requests to speak. I believe one might be associated with the application. Yes, and then another member of the public commenting. Oh, I apologize, Madam Chair.
As we've not had a chance to read Central Oregon Land Watch input this afternoon, I don't feel comfortable hearing a rebuttal yet.
Okay, so an applicant typically in a land use hearing would have the opportunity to provide rebuttal to testimony. And so that's something that I would have done as a matter for course. I was just trying to figure out procedurally in the run of show today, if you wanted me to do it now. I'm still planning to provide that rather than provide a written submittal unless this commission is planning to leave the record open, which at this point in time, the applicant is not seeking.
I do feel it would be better if all commissioners had the time, and I know it was submitted before the time of this meeting. Most of us have other jobs that we work and can't necessarily get in front of that computer or be aware of that information that was provided. If you have it in writing, I believe you said you did, we could accept that, and we would probably just keep them written record open for a week so that we have time to absorb that information.
Okay, so I'm sorry, I'm not quite, you're asking me not to provide any rebuttal to any testimony that's been submitted to this record so far.
Pardon me, Madam Chair, if I may,
Yeah.
staff, I just wanted to offer a little bit of guidance. So I think what Ken's referring to is typically a process that like a hearings officer has. So it's a little bit unfamiliar to the Planning Commission since applicant initiated text amendments are so infrequent. He's essentially asking, you know, as I noted in the opening slide, there's an opportunity following testimony where, you know, questions or discussion could be invited from staff or the applicant. So essentially that gives the applicant an opportunity during their presentation, you know, if something's discussed and a public commenter mentions something and the applicant wanted to address that during the hearing, there is that allowance. So I would say, you know, to the applicant's question, you know, I'd say it's up to you if you wanted to provide, you know, additional information right now as part of your presentation as you have time, or if you'd like to save it following public testimony.
Madam Chair.
Yes, Commissioner Cyrus.
Yeah, I guess, I mean, I've been to quite a few hearings over the years, and yeah, it's normally customary that at the end of the hearing, the applicant gets the opportunity to rebut any discussions and such that came up during the hearing, and I would certainly like to hear what he has to say.
And don't get me wrong, I did not mean it to be received that way. So let's proceed, give the rebuttal. I will hear the rebuttal as answers to questions I haven't read per se. So I'm fine with it.
Okay, with that, then I guess I'll wait and let the two members that are in public to testify, and then I will address any comments to the extent I have a response, just to make it clean. All right, thank you very much.
Right. And Madam Chair, if it's appropriate, we do have the Vice Chair Kiris here. So we were wondering if you were comfortable if she could call up the public commenters who have signed up here.
Absolutely. Absolutely. Thank you. Thank
Okay,
you, Vice
thanks,
Chair
Madam
Harris.
Chair. We just have 2 blue sheets here. Do we have anyone on Zoom who is interested in providing testimony? Okay, so our first commenter will be Doug White. And as Nicole said at the beginning, we're looking for about 3 minutes. If it starts to go over, we don't have a whole lot of people here, so we're not too worried about it, but I'll probably wave at you or something.
Madam Vice Chair, Chair, members of the commission, my name is Doug White. I'm a retired land use planner. I'm going on maybe 45 years in the game. I think I'm finally retired from consulting. I got one more project in the hopper, but I'm here to testify in opposition to this proposal and how it's laid out. Probably more so than what is being proposed. I was around when the 35,000 square foot mini storage facilities limit was added to the RC zone. It was actually an oversight as part of PIROC review. It was deleted inadvertently. So the county, the department, and the landowner that owned the Deschutes Country store, 4 acres behind there's vacant, proposed allowing them in the RC zone. It was approved at 35,000 square foot limit because, and I'll just talk a little bit about goal 14, to be consistent with goal 14, you have to be less intensive than what's allowed inside an unincorporated community as a result of a 1980s court case coming out of LCDC versus, or Thousand Friends versus LCDC Curry County. Major case under in this whole topic. So the provision, the proposal allows an urban use outside urban growth boundary. I can say a couple of things to that effect. It's kind of weird that the staff has taken an application with multiple lots of record. I know that you can't really make an application with multiple lots of record. You need to apply for per lot of record. So we got multiple lots of record involved. We got a zone within a zone. We've got a residential zone now adding a commercial use. I can tell you, if you've heard hearings with the MUA zone dealing with lavender farms, wineries, people out there don't want processing or production or commercial industrial uses in their residential zones. So there's a lot of Goal 2 issues. You know, Goal 2 says to establish a land use planning process and policy framework as a basis for all decision making. This proposal is not following the county's established land use process. They don't have zones within zones. You apply for the zone that meets the need. I've heard the argument that, well, this eliminates a lot of problems with applying a rural commercial zone to some place with all those uses. I don't know if you heard that the county has a limited use combining zone that was specifically adopted to deal with these kind of actions where you can, if a use is justified, you can apply the base zone and then you can limit the other uses that aren't justified. So this should be, for example, an RC/LU allowing appropriate size mini storage for a lot of record. So this is the kind of stuff that, you know, if I proposed that, I would have gotten nixed at the pre-application if I proposed something like this. Now, it's my understanding there was no pre-app. So it's unfortunate that we're spending a lot of resources here when this is just kind of not the norm for Deschutes County and their comprehensive planning. You have comprehensive plan implementing zones and you rezone for use if you can justify it. So like I said, I'm not necessarily opposed to mini storages in rural areas. I was supportive of the 35,000 square foot. So that's all I have.
Thank you very much.
Thank you.
Okay, the next and final commenter is Aaron Lafke.
Thank you and good evening. I am here on behalf of the directive applicant, Kramer Farms and Lafke Properties, to add color to the application and available for questions. And just so you understand, the Kramer Farms property has been in the family for over 55 years. You know, it was 35 years ago that Highway 97 was a 2-lane road. It's now a significant highway with decibel levels reaching near Portland Airport at certain times. This has lost its rural character a long time ago. We used to run livestock on the property, but we were constantly, after the highway widened, gathering cows because cars would come off the highway through the fence and the cows would go across the highway. So, this is a changed area. But we're also dealing with a lot of different uses within this small area. Bend. There are 3 mobile home parks within 1,000 feet of the property. I believe are in the MUA 10 zone. There's a junkyard, which is or auto wrecking facility, which is zoned industrial to reflect its original use pre-1975, I think. And most recently, since the city of Bend kicked people off of Hunnell Road, we've been in a running battle with squatters on the property and a lot of homeless people. In fact, it's almost a weekly chore, and we had incurred significant legal costs going through the process with the Deschutes County Sheriff's Office last year to get people off of the property that just simply pulled mobile home or travel trailers onto the property and started living there. So it's a constant fight. We're looking to do something that we can afford to have a secure facility. And I have a lot of experience with storage and RV and boat storage, so I'm available for your questions and address the main size of the facilities in terms of economic viability if you'd like.
Does anyone have any clarifying only questions for Aaron Lafke? Okay. Thank you very much. And now I'll go ahead and turn it back over to Chair Williams since we have heard from our commenters. Oh, you're on mute, Chair.
Haven't done this in a while. I think our next step is, do we have any questions for the staff or the applicant? Chair Altman, Commissioner Altman,
Thank you.
maybe
I do
one day.
have a procedural question for staff. So when the applicant was discussing, trying to save my notes and I just lost it. When the applicant was discussing, and you mentioned it also, Nicole, about changing the language to satisfy the concern of the city of Redmond and adding language that says that, you know, this area is not allowed in the urban reserve. Is that something that the applicant would do before this goes to the Board of County Commissioners, or even after that, if the board were to approve it, then it just is something that staff incorporates into the language? Or does the applicant sort of write their own text amendment and then the county accepts it? What's the procedure for that if they're going to change the language after the initial application?
Yeah, that's a great question, Commissioners. So, with the legislative process, it's a little bit more flexible, I'd say, than quasi judicial applications. So the applicant has, noted into the record that he's planning to add this additional criteria. The Planning Commission could request to see, an exhibit into the record added from the applicant to memorialize that. Otherwise, you could essentially, you don't have to request that. And during your recommendation, during deliberations, and ultimately your vote, you could, verbally note that change, and then we could request that information prior to going to the board. So there's a few different ways, but I guess as staff, maybe my recommendation would be to request that the applicant add an updated proposal into the record, just that written language, so that the Planning Commission has it.
Thank you.
And I also wanted to note, Madam Chair, the applicant had requested that additional time to provide some additional information. So I believe now would be the time to invite that from the applicant as well.
Yeah, absolutely. That's what I was going to say, unless there were any other procedural questions from the commissioners. Commissioner Stockamp?
Yeah, procedurally, I printed out the map of the three it's the properties that would be affected by this text amendment. And I was just curious, procedurally, were all the properties, which Nicole's just sharing, there's like roughly it's like 30 to 50 in there. Are they notified of what's at stake for their property? Just even though like at the Schwabe's not represented, I'm just curious, do they know that their property would have an effect in this text amendment?
Yeah, it's a good question, Commissioner, and this actually came up as well in the Highway 20 process. So our noticing for legislative text amendments such as this, because it's involving more than just one property, typically we follow our development ordinance, kind of procedures ordinance, that basically says we post notice in the Bend Bulletin and we post notice on our website, but we don't send individual notice to those property owners. We would only send notice to individual property owners if it were a quasi judicial application, meaning if it, specifically impacted, one property essentially. And I see Will's coming up to add more to that.
Thanks for clarifying.
Chair, Commissioners, the Planning Manager, Will Groves, just wanted to add in, there's something that I think would be a reasonable concern is if there's a text amendment which will limit somebody's property in a new way, they do receive direct mailed notice due to Measure 56. So in this case, because the universe of opportunities is being expanded, that direct mailing doesn't occur.
All righty, Mr. Katsaroff, if you would like to provide rebuttal.
Thank you very much, Chair Williams. Again, Ken Katzroff at Schwabe, Williamson and Wyatt. Will stole my thunder, I was going to say, because there was no reduction, but in fact, an increase of allowable uses. Real quick, I want to address Mr. White's comments. I would disagree. I don't think he's quite correct here. There are many uses and many applications that occur in Deschutes County that relate to multiple lots of record. I mean, we can think of a big one, which would be something like a destination resort, typically has many, many lots of record, et cetera. It's quite normal, actually, that one particular land use actually can straddle multiple different lots, whether you have a farm or any other sort of use. So that's just not quite correct. I don't think we all either have a goal 2 issue. This is following the county's established process. And I don't see that as creating a zone within a zone. So I wasn't quite following that one. But what I do want to talk about is Landwatch for a second, and Mr. Isbell's comments on behalf of Landwatch. And I'm going to kind of run through this as quickly as I can, but I want to give it to this commission at this point in time. It alleges that this is inconsistent with the MUA 10 zone purpose, and I just don't agree. We've addressed this in our application, but this specifically helps the transition between urban and rural uses. This includes storage for RVs, boats. It could be tractors. It could be whatever. The point is that it's an activity that is not inconsistent with the rural character of the zone. We just simply don't agree with that. I also don't think that the purpose statement in this particular case is a substantive application criteria. We can't be completely inconsistent, but it's not a substantive application or applicable criteria. I also want to note a couple of places where I think Landwatch is maybe overstating its argument, to be polite. For example, he says that mini storage is concrete pads and retail offices. I don't think that is accurate. In fact, the code actually permits using all weathered surface areas. That's a gravel parking lot. And the county regularly permits uses that are all weather surface. That's not concrete pads. It's not even asphalt. And in speaking about asphalt, this is a place where I think Landwatch is again overstating what's allowed in the MUA 10 zone. For example, one of the uses that is allowed in the MUA 10 zone is storing and crushing and processing of minerals and materials into concrete. That's essentially an asphalt batch plant. And so when we're talking about the types of uses that are allowed in the MUA 10, you already have significant industrial and commercial uses that are allowed in the zone. Mini storage is, in my opinion, a lot less impactful than a concrete plant, which is allowed in this zone. Other uses that are allowed are facilities that process forest products, so a timber yard, et cetera, schools, commercial stables, those sorts of things. Those may not be as impactful, but certainly manufactured home parks, RV parks, utility facilities, et cetera, are not inconsistent with the MUA 10 zone and are more impactful than this proposal here for mini storage and storage of boats, RVs, et cetera. So when you look at what uses are actually currently allowed in the zone, they are high intensity uses. I mean, concrete plant. Landwatch essentially argues that this creates unpredictability for existing owners. Again, I don't really buy that argument. The uses that are already allowed here are substantially more intensive. I've just run through some of them. I also don't agree that it is challenging with growth management, as I've already discussed in my previous statements. Landwatch argues that a particular OAR 660-004-0018 related to goal exceptions is not being applied correctly, and I disagree. It says that essentially any addition of a use would require a new exception process or has to be consistent with it. And I would note that the county has routinely changed or added uses in the zone. In fact, the zone has been updated more than 25 times. I'm not sure if all of them added or changed uses, but the zone routinely gets changed. Most recently, well, let's see, 2020, 2021, 22, and 2023. So almost on a yearly basis, there are tweaks made to the zone, some of which are new uses or changes to uses, and some of them are changes to other issues in the zone. So to say that every single time we have to look back at the original exception that was taken in 1979 is not necessarily correct. We disagree on the EC analysis being incorrectly done, or that the LM zone was not adequate to protect the Goal 5 resource. I'm not going to say a lot more about that, but the landscape management zone was specifically adopted in order to protect the view corridor here. And we believe, given the requirements of the LM zone, that it does. The county has already determined, for example, that this view corridor has been highly degraded on an application that was just north of this property owned by LBNW, which I will disclose Schwabe represented. The county adopted an EC analysis that determined that it was highly degraded, essentially, and Landwatch did not appeal that determination or that EC adoption. So that's binding on the county and can't be collaterally attacked now. I would also last thing I'm going to talk about is I would disagree with Landwatch's read of the Friends of Yamhill County versus Yamhill County case. And I think that they misrepresent what that case actually said. Sorry about my dog. There they say in their last paragraph of their letter, essentially, or not their last paragraph, but in their last section, that LUBA determined that, quote, no reasonable person could conclude that permitting a storage facility adjacent to UGB is consistent with Goal 14. And that is not what LUBA said. What LUBA said is that no reasonable person can conclude that particular storage facility, where all of the evidence that was unrebutted showed that the only people who would use it would be coming from inside the urban growth boundary, and where the county determined it was a rural use only, despite the fact that there were size challenges. It's just a flat misrepresentation of what that case said. So here, what we have is a rural use that the county has already determined to be a rural use, has adopted it into its rural code, rural industrial and other codes. And as a applicant, or as anybody, we get to rely on the fact that the county has already determined this is a rural use. There's clear case law that allows us to rely on the county's acknowledged comprehensive plan that this is a rural use. So I disagree that there's a Goal 14 issue in general. With that, I will conclude my remarks unless there are any questions related to what I just articulated or anything else about our proposal.
And Nicole, I think at this point, we are only allowed to ask clarification questions. Is that correct?
I can look to Stephanie. So I believe at this point, being that the public hearing is still open, I believe that essentially to repeat the question for you, Stephanie, there's a question about whether or not the planning commission can only ask clarifying questions of the applicant. So I was curious on your take of that.
Okay,
And the public
thank
hearing is
you.
still open.
Good evening.
And questions of the staff.
And questions of the staff. Okay. Good evening, planning commissioners. Great to be here. Stephanie Marshall, Senior Assistant Legal Counsel. And yes, the record is still open. So whatever you wish to ask of the applicant or staff is appropriate. And again, the chair is running this meeting. So, the chair can direct you all accordingly, but we wouldn't want to close the public hearing with questions that are lingering in any of your minds.
Do any commissioners have any questions for the representative or staff? Yeah, Nicole, I have one question. The screen you had up that had the mini storage units in Deschutes County, do you know the zonings of those? Yes, yep.
Yeah, so listed here, I apologize, it's really far away for me where I'm, thank you. Yeah, so just to run through this again, we have, based on our research, we found that there are 8 facilities that were approved and appear to be in operation. So 3 of those are in the Rural Service Center, 1 in Sun River Business Park, 1 in Tumalo Industrial, 1 in Terrebonne Commercial, and 2 in the Rural Industrial Zone.
Okay, that's what I thought. Alrighty, thank you.
Mhm.
Any other questions, commissioners? All right, at the conclusion of the public hearing, we have some options. We can continue the hearing to a date certain, close the hearing, leave the written record open, close the hearing and set a date for deliberations, or close the hearing and commence deliberations. Does any commissioner have a recommendation? I do know is some information in the written record that has been submitted probably after some of us were able to read it this afternoon.
Madam Chair, Commissioner Kelly has her hand raised.
Commissioner Kelly?
Hi, sorry, I'm a little late on the question, but I do have a question, but my mind was still trying to compute my question.
All right,
And
go ahead.
May I
Go
ask
ahead.
that now?
Yes.
My question is, when would, let's say I owned a property, let's say this did pass and it went forward and I owned a property and my neighbor was going to put this mini, apply for this mini storage, when would I be notified?
I can answer that, Madam Chair. Yeah, so the applicant is proposing this use as a conditional use. So as our process requires, there would be a notice of application sent after the application is submitted, which would allow for, I believe, 14 days of comments. And so that would be, and a land use sign would also be posted on that specific property. And then in that notice of application that I mentioned that's mailed, that would go to property owners within 250 feet of the property. So that would be the time that you would be notified and could provide comment. In certain cases in Deschutes County for a conditional use permit, they're typically processed administratively. So staff could, receive those comments and incorporate those into the decision, work with the applicant, or in some cases, sometimes these applications are elevated to a hearings officer for a more extensive public hearing. So it just depends on the proposal and if there are any matters of first impression. For instance, that's usually a reason why we would send something to a hearing. But otherwise, you would, as a property owner, under the current proposal, you'd at least get a mailed notice when an application would come in.
I think what my thought is yes, that there's like expanded rights to these property owners, but also I see that point, but there's also, but your neighbor could also put up a mini store. So to me, it expands your rights, but it also compromises what your neighbors could do to the property. So that's why I'm a little, just my mind is like, I wish that these other property owners kind of knew exactly what was going on instead of just putting it in the bulletin. Where that's kind of what my mind, that's the line of question, that's my line of thought process here on this, is just notification of this process. And I just wish that maybe the public could comment on this, because I would like to know, like, what do these neighbors think about these affected properties? What do they actually think about this?
Yeah, and Madam Chair, if I may, and I might invite Will or Stephanie up as well. I know I wanted to note that we did discuss this a bit during the Highway 20 application,
Yeah.
but because that's a separate record,
Yeah.
great question for us to address as part of this process. So the reason that this application was processed legislatively is that because we can perform, a basic level of GIS analysis to identify the potential number of eligible properties. At this point, it would be very difficult to actually identify the exact properties that would be eligible. And also because, some of these factors could change, again, like the expansion of a UGB or reconfiguration, like a lot line adjustment, lot consolidation. There's no way for us to, reasonably quantify that exact number to send notice to those individuals. But I guess, Will, if you wanted to touch on that.
Yeah, it's a reasonable question. I think in this case, because there's a relatively limited number of properties, it seems like a reasonable request. Legislative matters are designed for things that might affect large portions of the county. And so, our predecessors decided in the past to not require mailed notice to neighbors. You can imagine a scenario with like ADUs. If during the, I'm sure some people might object to having an ADU next door. If we had tried to do a direct mailing to all possible neighbors of all possible ADUs, the cost would have been. So, you know, what we have is our predecessors set up a rule to try and allow some type of information, as part of these applications. They are noticed in the bulletin, they're on our website. So, we make good faith efforts to do that, but we have to be careful too, not to be looking like we're putting our thumb on the scale. So, if there's a risk of there being an appearance that, if staff were to provide notice beyond what was required in any circumstance, it would look like we were drumming up opposition in the face of an application contrary to what was required in the code. So there are some disadvantages to, it would be interesting to hear about people potentially directly affected by this. And we're bound by a set of rules, and we try to follow them and not deviate from them, so that, the next time when there's, say, 500 properties that might be affected and, 2,000 neighbors, that we don't have having to do large mailings that don't have the resources for.
Madam Chair, remotely, and Vice Chair Karas, if I can offer some follow-up remarks. Peter Gutowski, Community Development Director. I think the other element that informed our accommodation of this application, an applicant-initiated application, was that they had proposed it to be a conditional use permit. And so there are very rigorous compatibility criteria that come along if this amendment were to be adopted, and if someone wanted to take advantage of it. That conditional use process really puts a tremendous burden on the applicant to demonstrate at a site-specific scale that the proposed use is compatible with the natural environment, with transportation and other factors. And so, while not a perfect answer, we felt that that additional level of analysis compared to, say, just having it be permitted outright subject to site plan, that additional analysis would afford conceptually, if approved, enough of an opportunity for neighbors to get engaged and to scrutinize that burden of proof. And then if they felt differently about the compatibility, then they could do so. But what we have right now, which is true that it affects a few number of properties, we don't have a formal proposal yet. So it is somewhat of a unique circumstance, but I would say again that staff made an informed decision that this was the right way to process it in relationship to the rules that are on our books, that inform procedural processes.
Thank you.
Any other questions?
Madam Chair,
Yes.
I just have a comment about the record. We can still read the comments even if we close the written record. You mentioned earlier we may not have had a chance to read them. We can always read them. I think if we close the written record, it just means we can't accept any more written comments.
Correct. My concern is about deliberating before we have a chance to read them. That was my main concern.
Yeah, I think we could close the,
Would you like
I
to
guess
make a
I'll just
motion?
Yeah, I'll just make a motion to close the hearing, both the oral and the written. But I'm also not super attached to that. So if someone else wants to convince me otherwise, that's fine. I just, we'll see if there's a second, but I'm waiting for a second. Yeah, no one's seconding it. So looks like the motion's gonna die. All right, somebody else make a motion.
Madam
Commissioner
Chair.
Altman?
Sorry.
Okay.
I would move to close, let me see if I'm getting this right. Close the public hearing, leave the written record open for a week. I would like to request from the applicant to put into writing his rebuttal. I tried to take a lot of notes, but I'm sure I got some words wrong. So I would just like to have in writing what his rebuttal is. So I'd like the record to be open for that. And then have deliberations. I'm not sure when, if staff could propose a date for deliberations.
You don't necessarily have to set a date for
Okay.
deliberations. We can just, notify you at one of your upcoming meetings when it's scheduled.
That's my
Second.
And why do you, Commissioner Altman, why do you make this motion?
Well, I would like to hear I would like a written rebuttal from the applicant, from Mr. Katsaroff. And I don't know that there are many people in the public who are paying attention to this, but if they are, I would, like to give them a week or maybe a week from tomorrow to send in any written comments.
Madam Chair,
Yes.
I just want to support the motion, even though I made a different motion earlier, but I think that Commissioner Altman brought up a really good point. I listened really carefully, but I haven't had a chance to read Central Oregon Land Watch's letter. And when I read it, I would like to go back to Mr. Katzaroff's comments and kind of just reference each one in reference to Mr. Isbell's comments. So I really like that idea. Thank you.
All righty then, we will vote on the motion. How about you, Commissioner Altman?
Aye.
Commissioner Cyrus?
Aye.
Vice Chair Kira?
Aye.
Commissioner Kelly?
Aye.
And Commissioner Stockamp?
Aye.
I will vote aye as well. The motion to close the public hearing and leave the written record open until July 18th, 1 week from now, has passed 6-0.
Madam Chair, if I may, just to run through some housekeeping on that. So yes, the written record will be open for 1 week ending on July 18th at 4 p.m. So all submittals would need to be received by the county by 4 p.m. All submittals should be sent to me, Nicole.Mardell@Deschutes.org. And then again, just for anyone who may be listening, we do have a kind of a file size limit from our server of 10 megabytes. So if larger than that, try to send multiple emails so you can kind of piece that out. Otherwise, we will manage the record, upload items as quickly as we can, and we'll work with the Planning Commission to schedule deliberations at a future meeting.
Terrific. Thank you, Nicole. And Mr. Katzaroff, thank you for your time this evening. So our next item is Planning Commission and staff comments. We will start with the staff.
Good evening again, your planning manager, Will Groves. Got a number of things going on, exciting times as always. Nicole, of course, will be providing an update on the comprehensive plan process. I wanted to let you know, we talked about this a number of times, but the Senate Bill 80 wildfire mapping process, the county had received initial copies of the revised map and were subject to an NDA, so can't tell you anything about that. But it is being that data is being released to the public on the 18th of this month. And it's our intention to follow the release of that data with a presentation to the board to help them orient the board to that public comment opportunity. The state has indicated that public comment will be open for 1 month. It's also our intention, time willing, that we'll bring that presentation that we brought to the board to you as well to let you kind of see what the maps look like, hear a little bit about some of the county forester's thoughts on those maps, as well as just kind of have a general discussion of it. It's not a hearing. It's just an opportunity to make sure that you're involved as part of our citizen involvement body. Of course, House Bill 3197, clear and objective standards continue to be underway. Those are those requirements for us to make significant code changes by July of 2025. And those are well in process. You'll be seeing coming your way shortly. We've got planned coming up housekeeping amendments. Those fingers crossed are boring. Just a number of things to catch up with state law or to make our code say what it should have always said. If we're doing that right, there's no choices to be made there. These are all things that are mandated or plainly need to be updated without any sort of discretionary action. And so those tend to be relatively simple. Also want to note that the Senate Bill 1013 RVs as rental dwellings, I think I talked to you about this last time, no real change since when last we spoke, that there were some concerns before the board about about service providers, particularly fire districts, making sure they had the resources necessary were this to be approved to ultimately approved to deal with these deal with the increased demands that these might place on such providers. I think just as a general update, current planning, we're in an interesting situation. We've been down from previous years and have had, both application and funding shortfalls. I think most people believe that there had been a lot of people sitting on the fence in higher interest rates waiting to act. And if the real estate signs around town are any indication, people are getting off the fence. And we had every year we have a major influx of applications right before the fee schedule changes, and we did again. So a very significant plug of work coming in, looking like we're going to have solid applications into the fall. And we also have some planned family leave. So we're going to have 2 of our planners out simultaneously during a work surge. So I just, to the extent that you hear from constituents that things are going a little slower, we know. We're doing everything we can. We're trying to get ahead of it. And, but at this time, the financial indications aren't strong enough for us to consider hiring. We are hiring for the building a number of additional staff. Peter will be speaking to some of those, but one of those will be 50% of an admin assistant, and that'll help unload some of our planners a bit. In the past, we've used administrative assistants to do some of the kind of more routine tasks that planners do, and that can be real helpful in clearing them up to do kind of more direct interaction with files and customers. So we're taking a very limited action in a kind of a constrained financial position. But do expect that things are going to gum up a little bit as we head into the fall. Was there anything else anyone was hoping I was going to cover this evening? Not seeing none.
Yeah, Madam Chair, Commissioners, wanted to give an update on the comprehensive plan. I gave an update at our June meeting, but just in case folks weren't there, we have 4 deliberations meetings upcoming with the board to discuss the 2040 plan. So they essentially directed staff to bring forward 4 chapters for detailed review. So we'll essentially open up those chapters and go through them in pretty close detail, including both the chapter text and also the goals and policies. So we have our first deliberations meeting on the 22nd to discuss chapter 3, farm and forest resources. On the 24th, we'll talk about chapter 5, natural resources. On the 29th, we'll discuss chapter 7, natural hazards. And then we had to move one meeting due to the fair opening ceremony, which is on the 31st. But the fourth meeting will be on August 5th, which will discuss unincorporated communities and destination resorts. So yeah, we are just essentially not providing a matrix for this one because it is, in the public comments and agency comments as well. We received a wide variety of different comments, in some cases really general feedback, in other cases red line edits. So we're doing our best to, summarize some of the key issues that were presented. But the board has been and will be reviewing the entirety of the record to look at all those detailed comments. So yeah, an exciting phase. And again, appreciate all the Planning Commission's work. And thanks for, again, being here tonight and for your work on these 2 applicant initiated text amendments. I know it's a slightly different process, so appreciate us all navigating that together.
Yeah, thank you, Commissioners. A couple of topics to bring to your attention. To the extent you may be interested, this has received some coverage from our local news outlets. This is concerning the Fort Thompson property, which is in between Bend and Redmond on the west side. I believe it's south of Deschutes Market Road. The Board of County Commissioners a year or 2 ago convened a feasibility study to look at, this is a property that the county owns, looking at the feasibility of establishing a campground there. It's generated a lot of interest and opinions, very vocal opinions. The board is going to convene a roundtable discussion on July 30th in this room, but it will be available virtually as well from 5:30 to 8. There's no, decision that's going to be made at that meeting. There's a lot of strong opinions. There's a numerous factors that make the concept complicated, and Will Groves has been actively involved relatively recently just to educate the board about what it might mean to establish a campground. What are the requirements? It's currently zoned exclusive farm use, has direct access on the Highway 97. So there's some transportation related matters. There's an irrigation canal. But anyway, to the extent you may be hearing about that, they're gonna discuss it. I think from a big picture standpoint, the board is trying to figure out if there's support for the concept. They could potentially apply for a grant through the State Parks Department to kind of further evaluate the possibility. So I think that's what's galvanizing them, that they have not yet they haven't made any kind of formal opinion that this is something they want to invest resources in. They're just scoping it. This just occurred to me today. It's given your involvement in psilocybin. This has also received some attention locally. Next Wednesday, there's going to be a hearing with the Board of County Commissioners on a psilocybin service center at Juniper Preserve, which we all know was formerly Pronghorn. I think you remember that testimony and that amendment, that through that amendment process, there was some clarification about that opportunity. A hearings officer, I won't get into details, denied the service center application. And it was appealed to the board, and the board agreed to hear it. So they're going to have a work session on Monday afternoon to prep them. And then there'll be a hearing Wednesday morning. So if Will can keep you abreast of that if you aren't interested in getting into the nuances of that. But to our knowledge, it is the first psilocybin service center being proposed in a rural area. So something that we're of course monitoring. I thought you might be interested in. Two more things. I have been thinking about the fall retreat. I don't have any logistical details to share with you, but I think we're leaning on focusing your attention in Southern Deschutes County. As soon as Nicole can navigate the Board of County Commissioners to get them to get comfortable with the comprehensive plan update, one of her duties is to pivot to start engaging South County residents on the Newberry Country Plan update. You'll recall that Deschutes County, and I'm about to apply for this likely early next week, on a $20 million EPA community change grant that would provide some real resources to deal with defensible space, home improvements, modernizing septic systems, doing some domestic well repair, deepening in a subset of Southern Deschutes County. And this planning commission will, regardless if that grant's successful or not, will be integrally involved as the citizen involvement arm, engaging Southern Deschutes County. So I'd love to, if we were lucky enough to get the grant, then it provides an opportunity to do, an open house, not an open house, but we could do a tour and then a meeting in Southern Deschutes County. And a few years ago, pre-pandemic, we used the Lapine Senior Center. So it'd be an opportunity to kind of, walk the grounds and get familiar with the area, the assets. There's Newberry Regional Partnership, which is an active, Nicole, I think, has talked about this in the past with Planning Commission. They're actively involved through funding through Central Oregon Intergovernmental Council to look at a broader strategic plan for the area. They're working on their, I think now they did a plan. Now they're working on the strategic plan, and they have members in the community that are really engaged to try to get more engagement and involvement in not only Lapine, but in rural Deschutes County. So you can kind of see I'm trying to piece this together for a meaningful tour and an opportunity to maybe hear from Newberry Regional Partnership, maybe even Central Oregon Intergovernmental Council. So I don't have a date. It's hot now. I'd much rather think about maybe something in October, a little cooler, but just wanted to let you know I haven't been forgetting that, because we had I thought a really productive retreat last year in the fall, and something that I'd like to replicate in just a couple of months. So more to come there. And then the last thing, just as Will noted, just wanted to let you know, we've completed our budget for our fiscal year 2024. We are well into fiscal year 25. The Community Development Department ended the fiscal year with a really strong June. Which, just not getting into too many details, we didn't have to kind of get into as much of our reserve funds and lower our kind of ending funding balance, which was very reassuring. We look ahead in the way that Will described, looking for steady development activity for a department that's dependent on development activity to fund its activities. We are in the process of recruiting for 2 permit technician positions. Commissioner Kelly has probably heard, just with her background, that we are experiencing some choke points an intake for building and on-site septic applications. That's really stemming from the fact that we had 3 resignations of seasoned permit technicians in the winter of 2024, January and February. So we are just short on staff, and we have all hands on deck trying to prioritize that intake from paying customers. So to the extent that you're hearing about that, we are owning it, and we are doing everything we can to address that situation today and trying to position ourselves for tomorrow, meaning, next spring in the summer rush, to have staff that are fully trained. Will mentioned the administrative assistant. We're also recruiting for a building inspector. So due to what looks like we may have we're just planning for succession, knowing that those positions are so critically important in the subject matter expertise that they possess. So we are balancing we're managing our budget, and at the same time having a greater understanding of what it takes to manage a department to meet our customers' expectations. And so I believe that these positions that I've just outlined that we're recruiting for will help get us there, and then we'll just adjust accordingly. So excited to turn the corner into fiscal year 25, and budgetarily, I feel like we're in a really good place. So those are my updates, Madam Chair and Vice Chair Karas. Thanks for the opportunity.
Thank you, Peter. Commissioner Cyrus.
I have nothing.
All right, Commissioner Altman,
No comments. Thank you.
Vice Chair Karas.
I just want to say I will be not here in 2 weeks for anyone who needs to know that. In case there's anyone else who won't be here, it's helpful to know in advance, so that we can, if we're not gonna have a meeting, it's always nice to know far in advance. So those of us that have jobs can go to our jobs and things like that. So heads up to everyone, I will not be here in 2 weeks.
Yeah, Commissioner Kelly.
I will be here in 2 weeks.
Yeah.
Thank you, everyone. No real comments.
All righty, Commissioner Stopcamp.
Yeah, just thanks for a productive meeting. No comment.
All righty. Vice Chair, I appreciate you taking the lead. I had earlier today emailed Nicole that I would be present in person, and had a change of events kind of come up. So I do appreciate you standing in. And Nicole, as always, terrific presentation. Thank you for the slide out you emailed me, and I'm sorry I overlooked those highlighted items. So other than that, we shall call to close the meeting of the Deschutes County Planning Commission at 6:44 p.m. on July 11th. Thank you.